Hello, and welcome to Housing Discrimination and Your Association, a guide to making sure you follow the law when it comes to fair housing. This presentation is brought to you by Royale Management Services to help you be a better board member and make sure your association follows the law when it comes to fair housing and housing discrimination. As a disclaimer, none of the information here is legal advice, nor should it be construed as legal advice. The contents of the video are merely for informational purposes and to help you understand the law. There is no client-lawyer relationship which is being created by this video. And if you have any questions, you should always consult with a qualified and licensed attorney who can answer specific questions about your situation. So what is the Fair Housing Act? Well, it was adopted on April 11th, 1968 by Lyndon Johnson, then president, and signed under the Civil Rights Act of 1968. When it was originally passed in 1968, there was only 4 main categories that were covered, which was race, color, religion, and national origin. In 1974, sex was added to that list, and in 1988, disability and familial status were included in protected classes as well. So what is fair housing? Fair housing is the right to choose housing free from unlawful discrimination, and federal, state, and local fair housing laws protect people from discrimination in housing transactions such as rentals, sales, lending, and insurance, and this includes protecting from discrimination by boards of associations, co-ops, homeowners associations, and condominium associations. Specifically, the Federal Fair Housing Act, as well as Florida Statute 760.20 to 760.60, prohibit discrimination based on race, color, religion, sex, national origin, familial status, disability, marital status, or age. You're going to hear those terms a lot, so just remember, you can't discriminate based on race, color, religion, sex, national origin, familial status, disability, marital status, or age. So what do each of these categories mean? Race is a tribe, people, or nation belonging or supposed to be belonging to the same stock or lineage. You cannot prejudice someone based on their race or what you think their race is. It doesn't matter whether they tell you or not, you can't do it based on a belief. You also can't discriminate based on color, which is the visible color of a person's skin. Religion, which is a person's affiliation with any religion, or also importantly, a lack of affiliation with any religion, which means you can't discriminate based on someone's lack of belief in God. National origin, which is the place of a person's birth or ancestry. Sex is whether a person is male or female. But note, Broward County has expanded this to cover LGBTQ individuals, which means sex also covers in Broward County whether someone is transgender, gay, lesbian, or bisexual, and you cannot discriminate against them in housing situations in Broward County. Disability. A disability is a physical or mental impairment that can substantially limit one or more major life activities. This can include things like chronic illness, mental illness, HIV/AIDS, alcoholism, physical therapy, physical handicaps, and many other conditions. And finally, familial status. This class covers children under 18 living with parents, or others with legal custody or with a designee of a parent with written permission, a person who is pregnant, or a person who is seeking custody of a person under 18. Properties can't refuse to sell or rent to families with children, and they can't deem property adult only. Now, there is an exception for this, which allows certain communities that are 55 and older and other retirement and older age communities to exist. But generally speaking, you cannot discriminate against a person based on their familial status, pregnancy, or any of those kinds of things. So, how do fair housing laws apply to condominium, homeowner, and cooperative associations? Condominium associations, their bylaws, officers, and management companies are all subject to fair housing laws. You have to follow fair housing laws or your association could face legal liability. A condominium association cannot take race, color, religion, gender, disability, national origin, or marital status into account when exercising their right of first refusal or considering an individual for residency. This includes making assumptions based on a person's name or address. So, you're not allowed to make any reference to any of those categories when you're determining your right of first refusal, doing interviews, and determining who's allowed to live in the association. Age and familial status should also never be taken into account, except as allowed within the legally established federal guidelines for housing for older persons, which are exempt from familial status and age protections under fair housing laws. So, what this means is you don't want to consider any of those categories when it comes to making a determination of whether or not a person can be a resident or an owner of the association. Condominium associations also have a requirement to make reasonable accommodations, also known as changes in rules and policies, in order to accommodate and allow for reasonable modifications for individuals with disabilities. Things such as making ramps, allowing service animals, and those kind of other activities are things that are covered by this. So understand, a service dog who helps a blind person is not a pet. Therefore, you're not going to be charging any pet fees or anything like that. They are a service animal. They're there to provide a service. You have to make a reasonable accommodation in order to stay in compliance with fair housing. Another example, someone is bound to a wheelchair. You may be required to allow them to modify certain common elements so that they can access those elements. For example, if there's a step up to the pool, you may be required to make a reasonable accommodation of allowing a ramp to be placed there so that they can also access the pool and other common elements. Another thing is they may be required to be allowed to modify their own unit in ways that the association bylaws and documents don't allow. What you want to do is make sure that you make any reasonable accommodation to allow these people to be able to live the life at which everyone else lives and to be accommodated. Now, condominium associations must also ensure that their bylaws are written and enforced in a manner compliant with fair housing laws. A lot of associations have older bylaws and don't enforce them. Now, the rules under fair housing say you're not even supposed to have those bylaws, but as long as you don't enforce them, you may be all right. One thing many associations may want to consider is amending their old bylaws so that they are in compliance with the law. Simply because your bylaws say something does not mean you can enforce it. Understand, federal law and state law trump over your individual association's bylaws. What are occupancy standards? The Fair Housing Act's protection against discrimination on the basis of familial status also prohibits occupancy standards which arbitrarily exclude families and unreasonably limit families with children's ability to obtain housing. In most cases, occupancy standards should never be limited to less than an average of 2 persons per bedroom. What this means is if you had a 2-bedroom apartment, you would not want to limit the ability for people to reside in that apartment building or condominium unit to only 2 people, because that would be an arbitrary, unfair use of occupancy standards to exclude and potentially exclude families' ability to access that housing. In most cases, a general rule of 2 people per bedroom is allowed, but there's no existing law or guidance that states that such a standard complies with fair housing in all circumstances. So it's best to make a reasonable judgment based on what the building's occupancy actually could be. Therefore, if you have a 2-bedroom apartment that happens to have a bonus room and very large areas, it may be that a 2-person occupancy standard per bedroom is not in compliance with the law. However, in most cases, the general rule of 2 persons per bedroom is a pretty good rule to follow. So what are some examples of some discriminatory use in occupancy policies? Let's go through some so that you understand what is and what is not allowed in your association. A family shall mean 1 person or a group of 2 or more persons related by bonds of consanguinity, marriage, or legal adoption. This definition is not allowed. This definition contains a direct limitation on the basis of marital status and also a restriction on the basis of familial status by excluding families who have legal custody or obtaining custody of a minor or any other familial situation, and therefore restrictions such as these ones simply aren't allowed. Another example, no more than 3 persons shall be permanently occupying or reside in any unit. Let's assume that an association includes units with more than 1 bedroom. Most two-bedroom condominium units are large enough to accommodate at least 4 people, thereby making a provision like this one potentially overly restrictive and discriminatory based on the basis of familial status. Now, let's say this entire building is made up of all one-bedroom and studio apartment units in this association. Now, a restriction such as this one may be within the law if that was the case. However, in any case where you have units that are larger than this kind of restriction would not be allowed. Use of any recreational facilities in the condominium by children may be limited by such times and in such a manner as the association shall determine by duly adopted regulations. This provision specifically targets families with children and very likely constitutes an unlawful restriction. It may depend on what the board or the association ultimately decides to place and what restrictions they place, but ultimately this type of regulation really is not going to be upheld under fair housing because it likely discriminates and targets families and children, and therefore would be unlawful. Units shall be exclusively for the residence of adult single persons or married couples without children below the age of 13 years old. This is clearly discriminatory. This places a discriminatory restriction on the basis of marital and familial status as well as age, and therefore clearly is not allowed. So, what are fair housing best practices for condominium associations? First thing to do is regularly review your bylaws as well as any of the rules, policies, and procedures to make sure that you are in compliance with all the applicable fair housing laws. This may include things like amending your bylaws as necessary to record amendments, arranging fair housing training of the association board members and other decision makers. Use of occupancy restrictions should not contain any unlawful or preference or limitations concerning familial status or any other unlawful areas. And any definition of family or restriction of family use should be consistent with fair housing law, specifically with fair housing's definition of familial status. Limits on the number of persons allowable occupants should be implemented with extreme caution. This is one thing that you want to make sure that you caution yourself with because we don't want to step on that wrong side of the law. And while some occupancy limitations are allowed, they have to be reasonable and reasonably related to the space itself. We also need to understand reasonable accommodations and modifications and develop appropriate procedures to allow reasonable accommodations and modifications for persons with disabilities. So we want to make sure that there's a procedure in place to identify and allow for reasonable accommodations and modifications as they may be needed in the association. Most important of all, the bylaws, policies, and procedures should be applied equally to all persons regardless of race, religion, sex, disability, etc. All persons should be consistently treated and receive the same quality of treatment. This means you shouldn't treat one person differently, and all of the bylaws should be enforced equally against all persons. You shouldn't treat your friend better than another occupant, and you certainly should not treat someone unequally based on any protected class. Moreover, any exercise of the right of first refusal or review of a prospective occupant or resident should not request, document, or take into account any protected class, such as race, religion, sex, disability, familial status, or any of the other protected classes, and you should not make any assumptions based on a person's name or any other information which you have obtained about them on any of those protected classes. So, what can you and what can you not ask? Well, you can definitely ask things like, how are you doing today? What makes you want to live in our community? Have you had a chance to review the rules and governing documents? Do you have any questions about the association? Are you aware of how maintenance and fees and how they are paid? Those are all things that are allowed. Notice they don't get to any information about any protected class, but merely make the person feel welcome and make sure that they understand the rules that come with living in this association. Now, there are a lot of things that you cannot ask, and some of them may seem innocent. One thing that you definitely can't ask is, what medical condition do you need a service animal for? When it comes to service animals, you're only allowed to ask a select limited number of questions. And none of those include things about what the medical condition is. You can ask why the service animal is trained if it's not obvious. However, usually it's best to refrain from asking too many questions about service animals and accept what the person gives you as the reason for their service animal and the fact that they need the service animal. Other questions include things like, where is your family from? Do you have any diseases? What country are your parents from? How did you learn Creole? Or are you trying to have a family? These types of questions all get towards protected class areas. And we don't want to make the illusion, even if it's not something that we're going to base it on, that there's some kind of protected class that's being gone after during the interview or orientation process. So these kind of questions are things to avoid, because that way we don't have to worry about any protected class issues coming up. So, is it an interview or is it an orientation? During an interview, we ask questions to determine if someone is eligible, we evaluate the person, and we determine whether or not they're going to be allowed to live in the association. An interview gives the person the impression that they may be denied if they answer incorrectly. An orientation, on the other hand, is used to make sure a new resident knows rules, procedures, and policies of the association. It's a meeting designed to help the new resident become familiar with the association. With that being said, after a prospective tenant, new resident, or new owner has been approved, based on the documentation that they've provided and the background checks that they have been provided with, it's best to conduct an orientation. Essentially, what we're doing is orienting the new resident with the facilities of the association, the rules and guidelines of the association. We're not using this as an opportunity to determine if someone's eligible, but rather to get them used to the association and make sure they understand the rules before they move in. With that being said, that's everything that you need to know about fair housing and making sure that your association stays in compliance with the law.